Own occupation insurance is insurance that's sold to someone for the purposes of paying benefits if he's not able to perform or she's not able to perform her usual and customary duties in their own occupation. In many states, particularly Florida, California, New Mexico, Arizona, Nevada, states, West states that tend to follow California law, California Supreme Court decisions, the definition of total disability is such that there is no room for partial disability. Because in the policies, just to give you a typical definition, total disability will be the inability to perform your important duties in the usual and customary manner. Partial disability will be the inability to perform some of your important duties in the usual and customary manner. Now, I defy anybody to explain to me how you can be unable to perform some of your important duties while you are not unable to perform your important duties. It doesn't say all of your important duties. And obviously, if a surgeon can't operate normally, regardless of whether you can still open the door to the operating room or still pick out a scalpel or assist in a surgery, he's going to be totally disabled, not partially disabled. And so in those states that I just mentioned, the law is that if you are unable to do your duties normally, you're totally disabled, regardless of how much money you're making, regardless of whether you're doing something else. They don't always simply say, okay, we're going to send you to an independent medical examination and our doctor is going to conclude that he disagrees with your treating physician. It's not always that simple. Often it has to do with the sophisticated analysis of one's occupational duties. Sometimes it has to do with, we had a case once with a court reporter. It became a famous case. Went to trial, we won the trial. The court reporter could not keep pace with the testimony of witnesses in her judge's court anymore because she had very serious injuries to her wrists. And she would work and could do it for an hour or so, but then the pain would kick in and she'd have to slow down, would have to interrupt the proceedings and so on and so forth. Believe it or not, the insurance company said, well, give us a list of your substantial and material duties. So she sat down, wrote out a list of what her substantial material duties were, and they included being able to process the information that she obtained in court, summarize it, put it together in a transcript, and file it with the Court of Appeal in a case that was going up on appeal. So they said, well, you can still do that. It's called scoping. You can still do that, and that's one of your substantial material duties, and therefore you're not totally disabled, you're partially disabled. Well, her judge, who was the presiding judge of the San Francisco Superior Court, actually testified on her behalf in federal courts. First time I've ever seen this happen. A sitting judge testifying on behalf of a party in federal court. And he told the jury, look, if you're a musician, if you're a violinist, and you can no longer play the violin, but you can still read the music, you're totally disabled, not partially disabled. And the jurors looked at each other and they got it immediately. But the defense lawyer for the insurance company kept on arguing that she was partially and not totally disabled. When they lost the case unanimously in the trial court, it went up on appeal, and they lost on appeal. He still didn't get it. I mean, maybe he got it, but he still stopped. He still kept making the same old argument. That's typical. I mean, it's typical of the way insurance companies look at things and the way that they want to view things so that they can underpay claims and save money for the insurance company. Chiropractors are a perfect example. If you have a chiropractor that can't perform all of the manipulations anymore, they can't practice chiropractic. They can't do a part of a chiropractic treatment and send out the rest of it. And so often a chiropractor will lose their practice entirely or sell the practice, and then the insurance company comes in and says, well, you sold your practice. You didn't even try to do it on a part-time basis. We're not going to pay you on a full-time total disability basis for that reason. Well, we had a case once where I was representing an anesthesiologist who had AIDS, full-blown AIDS. And he continued to work as much as he could, as long as he could, until finally just couldn't do it anymore. And he filed a disability claim. The insurance company sent the medical records, stack of medical records, back to their home office, where they were reviewed by a nurse. And the nurse concluded that he could still work. He was still at least partially, not totally disabled. Well, did the nurse talk to the treating doctors? No. Did the nurse examine the patient? No. Did the nurse even talk to the patient? No. What was the basis for the conclusion that the insurance company relied on? There was no basis for it. Now, that's a very extreme example and resulted in a very substantial 7-figure settlement above and beyond the policy limits, because that's really not okay.